As the company grows, we're going to talk about different types of financings that it might engage in. Early on, we're really talking about friends and family round financings, angel round financings. There's something that's creeped up that's called the Series Seed financing, and then there are the alphabet financings, the A, B, C, D, growth equity stage. There's all sorts of convertible debt financing rounds too, as well as equity. Those are a couple of the differences that might be encapsulated in a financing in a round or an angel round, a seed round. They might take the form of either equity or debt, one of the two. Convertible debt is a very advantageous way to start the company and finance it early on. Why is that? Ease of execution. There's a every law firm has a set of forms that's pretty good with a convertible promissory note or note agreement. And what happens is that investors at early stages will expect that. They will want a convertible promissory note which acts and feels like debt, right, in the beginning, right? And so, I have a debt instrument, but it converts into the next round. The value to the investor is that, well, look, I'm getting in early on the company. It's not spending a lot of money on transaction costs. They've given me this convertible promissory note, and I could stay as debt until, they do a financing round, and then I'll convert into equity. And it's usually a conversion at a discount. For the company, it's advantageous, again, because it's an ease of execution. It's quick, it's usually fairly costly, and it defers a valuation event. This is really important. As an early stage startup, you do not want to have an event that values your common stock early on. You want to be able to defer that issue for a while. Why? Because, like someone asked before, do I have to pay the exercise price on an option? How does that work? Well, if the exercise is really low, then you're not going to feel chilled to be able to exercise that. Some people might exercise it and start long-term capital gains immediately, right? But it's not a big out-of-pocket expense. As the company grows and its price per share of common stock, the fair market value of that increases. And let's say it's over, $5, $10, then you're starting to feel like that's an actually significant exercise price to pay out of pocket to exercise the options, and you may not do so. These are the advantages of the convertible debt. It's market acceptance, it's ease of execution, it's deferred valuation, which is great, and it's usually a little bit less costly than doing a full equity round. What's the disadvantage? There's this concept that has creeped up in the last 18 to 24 months called the valuation cap. And what that says is that I understand that I'm converting at a discount into the next round. And I may get, I've given you $100,000, but I'm going to get $120,000 of value in that next round. And, but the valuation cap says, well, except if you sell the company for over a certain amount, in which case you will convert my debt at the amount of this valuation. And it's basically a speculative amount. If you go back to the prior discussions we had as to valuation, they're picking an amount that sometimes they think it's a value. It's not. It should be an upside. But they're picking a number out of the air and saying, well, look, even if you knock it out of the park and have a $10 million valuation on your next round, I want to convert my convertible debt at a $4 million valuation. And so what happens is that creates usually like a 2.5x liquidation preference on the next round, right? Because what's happening is that I'm taking $100,000 of value and creating it at probably less than and converting it at less than 50% of the value of the next round. And those are sort of the disjuncts that we see, and companies have to deal with these issues. And what usually happens is there's discussions with angel investors who may have these convertible notes at a low cap, and the new investors who say, well, it's okay that you get a deal, but that's a steal, right? And I want you to renegotiate. And who gets stuck in the middle? The founders get stuck in the middle. Equity round, you will almost always on an equity round issue a preferred stock. You can do a common stock round. That's usually friends and family, but it is almost always a preferred stock. Here are some common rights that we see pertinent to preferred stock: a dividend provision, a preference on liquidation. Their money comes out first, right? They're convertible into common stock at their option. There's anti-dilution protection. If you sell shares below the price at which I bought the shares, then I get adjusted. Usually adjusted on a weighted average basis, which accounts for the new money into the company. Investors in preferred stock usually ask for board rights. That's significant because that means that they're going to have input, daily input perhaps to the company, but certainly they will have a seat on the board of directors and be able to use that to vote on anything that's important to the company. Right? There will also be these protective provisions. Stockholder veto or approval rights is what we call them. I call them the thou shall nots. Right? You shall not do as a startup, any one of these things without the approval of the holders of the preferred stock. And those can be restrictive, and a lot of times startups and founders are not used to that and will essentially balk at this. But these are commonplace. Redemption rights used to be in vogue, not there so much anymore. Those are simply after X amount of years, I get to put my stock back to the company for a price. Sometimes it's cost, sometimes it's cost plus interest, sometimes it's fair market value at the time. Other rights, registration rights, register my stock if we're going public, rights relating to the sale of companies by other stockholders. Do I get a right of first refusal? So paradigm again, Dave and I have a company. If you're selling your stock, do I get to buy it, right? And under what terms? And how do we negotiate that? Forced sale or drag along rights. We have a company with 100 investors, right? But only 15 of them are actually have any material amount. What do we do with the others if we're selling the company? A lot of times we'll institute what's called a drag or a bring along right, and the company will say, look, if we have approval of the board of directors, of the preferred stockholders and majority of the common stockholders, everyone's coming along. So this way we don't have people that are exercising dissenter or appraisal rights on an M&A event, right? So we commit everyone to be on the same page. Sometimes they want to be able to hire or fire, or approval over termination rights. Those are typical. And that's the two types of venture financings that you'll most often encounter: a convertible note financing and a preferred equity financing. Questions?
The pref shares, I guess I had 3 questions. One is, do they carry mandatory dividends? 2, do they usually carry any coupons? And 3, how does the anti-dilution work if you know you're going to be raising financing further down the road?
Yeah, so a coupon and a dividend are synonymous for equity. Coupon would be for debt, right? So, but on equity, they often will carry a non-man. It used to be the case that there was a mandatory or accruing dividend that was asked for by investors and received. That is no longer the case. The dividends are usually when, as, and if declared. And the preferred stock simply says, look, either of 2 things. We'll have a 6% dividend that kind of is not cumulative, but if you ever declare a dividend on the common, you got to pay us the 6%, and then you basically pay us pro rata as though we converted, or they'll just say just pay us pro rata as though we converted. But the dividend, startups are not paying dividends. You need the money you need to retain earnings to actually sort of fund the business. So I don't see a lot of startups declaring dividends at all. The mandatory dividend is what used to happen, is it would accrue from year to year and then be payable on an exit event. That's a little off market now. And we don't see investors asking for that as much. They still do, but the market has shifted to an investor-friendly, a founder-friendly environment, and we don't see a lot of mandatory dividends. Anti-dilution is going to occur naturally over time, right? So assuming that the company keeps increasing in value, they're basically the new money is going to come in at the new valuation, and everyone else is going to be diluted pro rata. But their value of the shares ought to go up if the valuation's up. On a down round, it's a completely different issue. Right? But so the option pool, each time you do it, you're going to refresh the option pool. You come up with a new valuation, new price per share. Each time, this pattern will continue to occur until it's sold.
So attorneys are very expensive. Startups don't have that much money. What advice do you have for young startups without that much cash to seek legal advice? I know there's pro bono work, but that can only go so far.
Learn as much as you can on the blogosphere. Sometimes there's a lot of misinformation out there, but learn as much as you can. Find an attorney that you trust and that does this, and offer to take them out to lunch. You know, like I joke about it a little bit, but one way to really get a lot of value is to be in, you know, as a startup, be in the community. You will learn a lot. I get a lot of questions at networking events, and we talk to people about that, right? In addition, right, those are the baselines. In addition, you want to go to law firms that do a lot of this, because the more you do, the more efficient you are, right? There's a theory, well, we could just go to, you know, our cousin Joe, who is a lawyer, but he's a divorce lawyer in, you know, Indiana, and he might get through it because he's a smart guy. But if you don't do this 100 times a year, you may have different opinion on who should pay for the option pool, right? Things like that. You may have a different opinion on you know, whether or not you should negotiate this right away. And what happens to the startup? You get a lawyer that starts negotiating this stuff when 99% of the lawyers don't, start to increase costs. So knowing this and doing this a lot will actually, you know, decrease your costs. Then, you know, there are online resources that you can use to help. You know, LegalZoom, Rocket Lawyer. I'm not promoting them, but they offer some good products for what they are, right? And it may be a good starting point to then go have a lawyer look at, right? And those are the things. And there's some great books out there too. Just, you know, continue to ask people in your network and find the right information. But there's a lot of information that's out there that's helpful. And you should be able to find it pretty cheaply. Someone asked what books I like. Making Ideas Happen by Scott Belsky is a great book for building a startup. Jeff Busgang, Mastering the VC Game is a terrific book. You know, if you're interested in the legal side, I believe it's called The Fundamentals of Venture Capital, right? That's Joseph Bartlett, who's kind of known as, like, you know, a very well-known figure in New York City venture. Those are a few different good reads. Also blogs. You know, I'll hawk the blog of my partner Ed Zimmerman, which is you know, in the Accelerators blog on the Wall Street Journal. Take a look at that. He's writing, you know, a couple times a week about issues that are really pertinent to startups.